Okay, next is, so basically that whole section is gifting. Do I want to allow gifting? So we've done special designations are trust. Next we did gifting, and it gave various options. You get to write exactly what you want. I put in italics to help you understand what those different provisions on gifting are. Next is designate beneficiaries. Say you're a member of the Maine State Retirement Fund because you work for the state. In the olden days, and maybe in the future days, you get to designate a beneficiary upon your death. Do you want your agent to be able to talk to the retirement fund and change your designation? Maybe you do, maybe you don't. It seems like a pretty serious delegation of powers, but you get to think about whether you think that person can be trusted, your agent can be trusted, that they aren't going to just name anybody. They might say, oh, Sue's named 2 different people and they both died. And why don't I change? I know who else she'd like to help after her death. So why don't, so my agent will have the ability to change based on the fact that a change is needed. Alternatively, you don't want to give that power to somebody if you think they might change the designation because they want to put their own name in there, okay? And you wouldn't have wanted that. Maybe you would have wanted that. Maybe you don't care. Maybe you think, yeah, that's fine. Okay, next is another option for you to think about, and it has to be specifically designated, is the option to waive rights under joint and survivor annuities. If you happen to be lucky enough to have an annuity, do you want them to be able to change who gets the benefits? Again, I'm going to go through this list fast now because I want to get to wills, because a lot of you had will questions. Next is fiduciary positions. A fiduciary is like somebody you trust with finances, a trustee, somebody who has a fiduciary, semper fi, has to be honorable, very faithful to what your wishes are. Are you going to allow them to decline or resign or renounce any fiduciary positions to which you may have been appointed, including but not limited to personal representative of an estate, trustee, guardianship? Are you going to let them change when you're responsible? If I were responsible for you, and I take that very seriously, in my durable financial power of attorney, am I going to, and if another person, say you over here are my agent, do I want to give you that power to do what I take great responsibility for in protecting you? Can see the seriousness of that decision? It could be that I trust you completely, and I know that this gal over here will do right by me as I try to do right by this fellow over here. But again, you see where that trust issue comes in? And if you can trust somebody, you're golden. If you can't trust your agent to that extent, nothing against the agent, it's just you're being extremely careful, and that's an honorable decision too, okay?
Well, they're not relatives.
The joke was, as long as they're not relatives, and we knew instantly it was a joke. Okay, next is releases and disclaimers. Releases. If I sign a release for a release of my medical information, it's me saying, oh my goodness, somebody else can know all about my medical information. My privacy issues are there. Would I trust my agent to be able to sign to release my medical information? If I trust them, I will. If I want them to have all powers possible, talk about it with your agent. I can just say, not that I don't like you and love you and trust you, it's just I'm really private and I don't think I want that. Or maybe it's no big deal. You get to decide, okay? This document, again, walks you through it, so it raises the questions so you can decide. Next is, any rights in statute that I can pass along to my agent, I'm ready to give those away to my agent. Again, how broad or how narrow a document of how many rights do you want to give away? If you've got somebody you can trust, give them all. If you have, if you're not that trusting, even though you love people and you think highly of them, so be it. That's your right. This is your document. Okay. Intangible personal property. Do you want them to be able to, do you want to give them, your agent, that right? Again, examples of intangible personal property would be a promissory note. I owe Sally, no, Sally owes me $300. And what I would be doing is saying that my agent could, compromise that $300 and say, all right, you owe her $300, I'll take $150 on your behalf. Do I want to give my agent that power? Okay. Next is, do I want to give my agent the right to borrow money on my behalf? Next, do I want to give my agent an opportunity to take out a loan in my name? Next, do I want to give my agent the right to deal with my personal property, to sell, release? Do I want to give my agent the opportunity to sell my beloved piano? Maybe you do, maybe you don't. Your call. If you like it, keep it. If you don't like it, cross it out. Easy enough? Next is, do I want to give my agent the right to name substitute agents? Again, say this fellow names me as his agent. I take the responsibility seriously. Do you want to give me the power to say, all right, you gave me that power because you trusted me. Do you trust me so much that you would trust me to give that power away to somebody else? Maybe you do, maybe you don't. Here's the chance to specifically think about it and check it if you want it. Okay? That's it. That's essentially it. Goes on. Yes, question?
Some of these additional powers might be okay for my wife, an agent, but maybe not for a secondary agent. How do I differentiate that?
So the question is, some of these powers might be okay for my spouse, but maybe not so okay for a secondary. So say you named your wife as your agent, and your wife died, say, hypothetically, and your successor, your secondary agent, had those powers. Excellent question. What you can do is saying, I check all these things below if it's my wife. If it's my secondary agent, I revoke all these designations. So you explain what it is you're saying. Alternatively, after your spouse, say, were to die or become incapacitated, you might redo the whole thing and just make it clean and limit the powers. My sense is to be...
If I'm incapacitated, I may not be able to...
Right, so while you do have capacity, my suggestion is you get to put anything you want. You would say, I'm saying these powers are given to my agent if my agent is my wife. If my agent is no longer my wife, then I am not designating these.
You better carry this with you.
Pardon me?
You better carry this with you.
He's another joke from the fellow on the right. He's getting in a jokey mood. He says, you better carry this with you so you can change it all the time, I presume is what he's saying. But really, once you do it, you'll be glad you did it. You come back to it every year, or maybe every 6 months. Maybe you do it once and you get comfortable with it. And a month or two later, you say, oh yeah, I'm going to print another one, do it all over again. I know better what I want now because I've taken the steps. I've given it some thought. I've had the conversation. I am so much farther along the road than I was as early as 2 months ago because you've taken the steps and you've had the important conversations. Okay, why I said when I got to the next page is that's it, is you've done the bulk of the decision making. At this point now, we're only getting into legalese. And basically part 3 is construction of authority. And basically, it's giving the legal versions of everything possible that these legal words mean. I don't mean to be glib about it, but it's a lot of legalese right here based on what exactly are these powers, how can they be construed, and this is based on lawyers who are expert in this area. And next is interpretation of governing law. Basically this says this is a Maine financial power of attorney. Maine law applies. Question I get at other settings is what about the people who go to Florida for over half the year? The recommendation from the legal community is you might want to have a Florida financial power of attorney. What I read today is, does Florida have a similar uniform act? Yes, they do. They're one of the states. So it could be the doctors and, the financial people who are going to be relying on this financial power of attorney in Florida will be very familiar with the form, and they'll be able to honor it. But the point is, this is Maine. We're in Maine. It's good in Maine. And if you stay in Maine forever, Maine law will be the easy law that we apply. If you move, you might want to look around online to see what the new state where you are living has for a form, because you probably want to make it easy for the officials in that state to work with something they are familiar with. It's in your interest. But this is Maine form, and Maine law applies. So that was a quick going through of a lot of that. Next is liability for refusal. Apparently, lawyers were getting upset because they were being paid to do these financial power of attorneys, and these agents were going to the banks and wherever to use these financial power of attorneys, and the institutions were hesitant. And they would get calls from their clients like, we paid you for this form, and it's not being honored, what's wrong? And well, anyway, lawyers would be thinking to themselves, wait a minute, this is a good form, it should be honored. Let's make it so that if the institution isn't going to honor them, that they have certain steps they have to take, and then if it ends up in court and the institution loses, the institution has to pay lawyers' fees. It's a way of putting teeth into it, saying this is an official document, the person has followed, done as was required. We want to respect that. And so if the person has done as the law allows, let's honor that, and let's make it so that if somebody or an institution doesn't honor it, that there is a price to pay for not honoring it. This is what was added in a recent version of this form. Again, it's mostly legalese that when you go to the seminars on these, they'll talk about more than we need to now. Suffice to know that's essentially what it is.
This is recent?
Yeah. This document became effective in July 2010. It's the newest and best. It's the most current. It's the most current form. I got it online. I got it at a seminar on financial powers of attorney. When the new law was coming on the books, I attended a seminar, and so the Maine bar provided the speakers, and the speakers provided the form. The other forms I got from the statute books, Maine statute books. Maybe with time this will get into the statute books, but I don't think I'm pretty sure it's not there yet. I got this from the Maine bar presentation, based on the new law, people who had written the new law. Okay. Okay, effective date and durability, the same thing we got to with the medical power of attorney. When does it become effective? Okay, here's your place. Let me read through on this durable financial power of attorney shall take effect when executed by me and shall not be affected by any subsequent disability or incapacity. That's the default. It's durable, it's effective immediately. Unless I check the options. This durable financial power of attorney, shall take effect at a future event. You get to name the event. And also, or it becomes effective upon my incapacity, okay? You get to check the option if you want. The default is it's effective immediately. Next is compensation. Should somebody you name as agent be compensated? Your call. My ethic or my thought is that for everyone who works an hour, they deserve an hour's worth of wage. And also, it seems like when somebody is doing the due diligence of paying your bills, that's work. And it gets scary too. It's somebody else's money. You've got to be more responsible. You've got to know what accounts they have. You've got to do a fair amount of research. You just don't walk into someone's life and know if they have a CMP bill or what bank they're at. You've got to organize it. It's hard work. So what's reasonable compensation? It's a common sense test. There's also a statute in the books that basically says, well, what's the person's experience? How often do they do this? What are they losing out on income when they're tending to my details? And also, I would say that if you have somebody doing all this work for you, and they come home at the end of the day and they've earned minimum wage for 8 hours, that's something. That's something to buy a dinner at night or go to the grocery store. If they've come home at the end of a day and they haven't earned a cent, it's been really hard work, it's hard. You know, you want to keep these people energized. You want to keep them fueled. And so I recommend compensation, and it doesn't need to be extraordinary. But if you came home at the end of the day, even with just $20 in your pocket, it's something that you're not driving home having spent money on gas, having tackled these hard projects. So I recommend keeping that compensation and putting in what you want for a reasonable fee. Next is successor agent. For whatever reason, that's put down at the end. So that means, say that you've named Jack and Jill as your agents, but then at the very end you say, well, what if neither Jack or Jill can do it? Then here's where you can put who you name as your successor or substitutes if one and two can't do it. And then you put their city and state. Next is, you know how I said a guardian, in the medical power of attorney we named a guardian if by chance anybody required us to go to court to get a guardianship. A guardian takes care of the person, and if an institution required us to go to court to get something other than this financial power of attorney, to take care of our finances, that is a vocabulary word. It's called a conservator. So this case, the protective proceeding would be if an institution requires me to go to court to petition for a conservatorship, who would I want the judge to name as conservator? So it could be this financial power of attorney is all you need. You've done it on your own. It's a fairly quick and easy, without a whole lot of formality document that is a very powerful document that works in many, many cases. Say you get to the one situation where it isn't strong enough and the institution is saying, I don't know, you're asking to do a lot as an agent, I'm a little unsure, and you get upset and go to court, and the judge says, oh yeah, I'm not going to assign attorney's fees. I can see the institution's concern. So then you go to another court and you petition for guardianship. When the judge reads that you have done this advance directive and you've named somebody for this event, the judge will do everything possible to honor your wishes because you've told the judge when you had capacity who you wanted. That speaks volumes, okay? So here's your chance, and it could be you designate the same person as you've named your agent. You follow me? But here's your chance to put somebody in there. Lastly, last page before the signature requirements is notices. So if you name the gal next to you as your agent, you might want to let her know that. So at the end is a notice to both you saying, you've done this legal document. This is a very serious legal document. It's called notice. The first paragraph is notice to principal. Okay? You read that and say, yeah, that's serious. And yeah, okay, I comprehend. And I enter this legal document. I sign it knowing what I'm doing. I know it's a serious legal document. Why would you want that? It's sort of a wake-up call. Everyone, this is serious. You're doing something very serious. Not to scare you away, but to make you realize that you are giving away some of your powers. I encourage you to do it. I think more people should do this. But this is a wake-up call saying this is serious. Don't think it's not. Okay? Next is the notice to the agent. The same thing. This is essentially give a copy to your agent saying, and he or she reads this and says, okay, I get it. This is serious. I do not take this lightly. Okay? It's just called, I call that the know this is serious provision. And it comes right before you sign. Okay? Lastly, you're signing, and you're going to sign, and you're going to have two witnesses, and you're going to have a notary. Maybe you don't need the two witnesses. Maybe you only need the notary, but why not have it all? Because it's a solemn occasion when you do a legal document. Why not give it all the muscle you have? So if there's any question about whether you were competent, you've got the witness there who can be called to say, yeah, I talked with him. He knew what he was doing. Okay? That's that. Any questions? Yeah? Okay, two questions.
The person is alive and given her full, that's her agent. power to sell anything. She could sell a home if she wanted. Now the person dies, that stops.
Well, you have,
That authority stops.
well, if you haven't named a successor. So the question is, what if I'll use myself. What if I name an agent and then that agent dies? Does this whole document stop being effective because the agent is dead? And my answer is, if you haven't named a successor or you haven't named a co-agent, you have no one to have the powers. So essentially it stops.
This is going to go into wills to it.
Okay. Other question?
The witnesses would have to sign in the presence of the notary as well?
Well, let's read it because it will say exactly on the wills, yes. But let's read this because, okay, so look at the question is, do the witnesses need to sign in front of the notary? And I said, let's look at what the language says. If I remember right, there might even be not even the requirement that it be witnessed, that it just be notarized. And if I am right on that, the reason I would have kept the witnesses in this form is I believe in giving it all the muscle you can give it. And it's such a easy requirement to get witnesses, to give it that muscle. So having stated that, now that the question is, does the notary have to say, is the notary saying that he or she saw the witnesses sign? Or is the notary saying he or she saw the principal sign? And you look at the language and it's saying that she saw the principal sign. So the answer would be no, the notary is notarizing that the principal, the notary saw the principal sign. That being said, there's nothing like a nice table with 4 people knowing what they're doing and everyone appreciating this is a solemn moment and the right hands know what the left hands are doing. So everyone is together. If there's ever any reason to question, you don't have just 1 or 2. You have at least 3 people who can say, oh yes, he knew what he was doing. We did it together. We followed, we created, it was a solemn, we were serious. This wasn't any shoot from the hip, in between passing the casserole sort of situation. This was us all focused on this important legal document so that nobody can question it. It's bulletproof. Okay?
But it says signed and sealed in the presence of, so you signed it in the presence of your witnesses.
Yes, right. Oh, good point. Excellent catch. So she's helping me, and basically you're right. It's basically, the questioner just said that when the witnesses are signing, it says signed and sealed in the presence of first witness and second witness. So that means that the witnesses also saw the principal, so everyone will be doing it together. Thank you. Yeah, good, yeah. When in doubt, read it carefully. Yes?
Say to the person who's just speaking, that when I've had documents signed, I just have it done at my bank, and the witnesses, they use the witnesses right there. So it's very easy to.
Ah, good. Okay, so what the person in the audience just commented is, in terms of that formality and finding an easy way to do it, she's gone to the bank where the bank has witnesses ready and available, and it gets notarized and signed and witnessed all in one fell swoop, and it's done in a perfect way.